Good afternoon. My name is Chris Christensen, and it's my pleasure to present the 2017 Law Day CLE. I am an immigration attorney, and I've been practicing exclusively immigration for roughly the last 5.5 years. I work at Andrade Legal, both out of a Boise office and an Ontario, Oregon office. Before I get started talking about the substance of my presentation, I do have a couple of disclaimers and caveats. First of all, due process is phenomenal. Due process, in my personal opinion, sets our country and our form of government and the judicial system apart from many other countries in the world. People have a right to know what the accusations are against them. They have an opportunity to be heard, and it provides protections in so many different contexts, not just the criminal or civil, but in a variety of contexts. But that said, due process is only great when you get it. And the vast majority of my presentation today really isn't in line with the Law Day theme because I'm not going to be singing the praises of due process. I'm going to talk about specific immigration encounters and particularly several forms of deportation or removal that do not afford the non-citizens due process rights. Second of all, second disclaimer, I'm fully aware that due process is derived from both the 5th and the 14th Amendment, and only one of those is the Law Day theme this year, the 14th Amendment. I'm not going to distinguish between rights that are derived from the 5th Amendment or the 14th Amendment during my presentation. And then final disclaimer or explanation is that I love my job. As an immigration attorney, I get to help good people on a daily basis, people who came to this country for the same reasons my great-great-grandparents did, to work hard, for religious freedom, for educational opportunities, to provide a better life for their family. Now that said, my job can be very difficult and very stressful. The Ninth Circuit has said in a footnote that the Immigration and Nationality Act is second in complexity only to the tax code. Part of the reason for that is it's piecemeal legislation, quite often reactionary, that's been put together over the years. Second, right now, obviously, we have a lot of new direction coming from the administration, and it's extremely hard to advise clients or even potential clients about what they can expect to happen when things are changing so quickly under this new administration. And finally, immigration law and immigration in general is a subject about which everybody seems to have a very strong opinion, and yet very few people really understand how complicated it is or how it really works. I actually hesitate to tell some people sometimes that I practice immigration law. I tell them just that I'm an attorney. Again, everybody's got a very strong opinion about immigration law. So those caveats and disclaimers aside, I'd like to explain a little bit of the terminology I'm going to use today. I will use the terms deportation and removal interchangeably. It used to be called deportation and deportation proceedings under the Immigration and Nationality Act. It's now called removal and removal proceedings, but again, I'm going to use those terms interchangeably. Second, I'm going to talk today about both grounds of removability and grounds of inadmissibility. A ground of removability can be applied against a lawful permanent resident or a visa holder or somebody who was inspected and admitted or here in legal status. It's basically a reason the government can allege to kick you out of the United States. A ground of inadmissibility is kind of what it sounds like. Somebody's essentially knocking at the door seeking admission. It's only slightly oxymoronic in that you can be seeking admission from here within the United States. So for example, if somebody's been here for years undocumented but has an avenue to apply for status, they are seeking admission even if they've been physically residing in the United States for the last 20 years. I'm going to talk about the term alien. It's not my term. It comes from the Immigration and Nationality Act, and basically alien is a term that describes anybody who is not a U.S. citizen. A lawful permanent resident can be an alien, a visa holder can be an alien, somebody who's undocumented can be an alien. Those are all aliens. Again, it's not my term, but I will probably slip it in a few times during this presentation today. And then finally, I'm going to talk about non-immigrant visa holders. Those are people who are on temporary visas that allow them to either work or study or visit the United States temporarily. And then we have this broad category of what's called undocumented people. Undocumented people are really comprised of two distinct categories. Many people think that everybody who does not have legal status here in the United States snuck across the border. That's actually untrue. About 40% of the people without documents entered the United States on a valid non-immigrant visa and then overstayed. So that's one category, a visa overstay, and the second category would be people who did enter the United States without inspection.
Another common misconception as far as immigrants is that of the 12 million undocumented people here, they all snuck across the border. It's not true. About 40 to 45% of those 12 million people are actually visa overstays. A lawful permanent resident is somebody who is entitled to work and live permanently in the United States, although the term itself is somewhat of a misnomer. You can lose permanent residence for a variety of reasons, and that doesn't necessarily have to be conviction of a crime. You could simply lose it by spending too much time outside of the United States. And then finally, a notice to appear is the charging document that starts removal proceedings in front of an immigration judge. So, little bit of a roadmap, talk briefly about the 14th Amendment and some of the rights that it does provide. I'm going to talk generally about immigration encounters, and then I'm going to talk about 5 different forms of removal or deportation in which the immigrant is actually not entitled to see an immigration judge, and talk about some of the due process concerns involved there. So, 14th Amendment was ratified in 1868. It's the longest of all the amendments. It's got 200 words in it. It has 5 different sections, and in my humble opinion, some of those that are most important are birthright citizenship. If you're born in the United States, you're automatically a U.S. citizen. There are a couple of exceptions, but for the most part that holds true. You're entitled to due process in courts of law, equal protection under the law, and then the 14th Amendment also extended the applicability of the Bill of Rights to the states. The 14th Amendment is one of the most commonly litigated amendments in the United States, and it's formed the basis for some of the most fantastic U.S. Supreme Court decisions, such as Brown versus Board of Education, Roe versus Wade, and Oberfeld versus Hodges. So, immigration encounters and the lack of due process, you don't actually have a 6th Amendment right to an attorney in immigration court. And in fact, ICE or the government would argue that you have no right to counsel whatsoever until that notice to appear has been filed with the immigration court. Again, the process that starts your deportation proceedings. Immigration courts are administrative. The judge is an administrative law judge, and you don't have the right to counsel because of the 6th Amendment, but once in court, once that NTA is filed, then you do, because of 5th Amendment due process rights, you do have the right to an attorney as long as you can pay for that attorney. Here in Idaho, unfortunately, there are very, very few organizations. In fact, you have the U of I Clinic, and then you have a new program called Project Lara through the Concordia Clinic. Those are the only 2 services that are currently providing attorneys for indigent defendants facing removal in front of an immigration court. They have very limited capacity, so there's just not a lot of free attorneys out there, and you don't get such a thing as a public defender. Interestingly, the federal rules of evidence don't actually apply in immigration court. They serve as guidelines. I find that to typically mean that if the government is arguing the rules of evidence apply, they apply, and if we're arguing they apply, they don't necessarily apply. Just being slightly sarcastic, but that is based on experience. My first encounter with due process rights in immigration court actually occurred while I was a law student. So our client had been convicted of a fairly serious crime. He was a lawful permanent resident, and he entered an Alford plea to that crime. And for those of you who are unfamiliar with an Alford plea An Alford plea is basically an acknowledgement that the state may have sufficient evidence to convict you. Rather than roll the dice and go to court, you're going to enter a plea but admit no culpability in the underlying crime. So our client had done that in the criminal proceedings and landed in front of the immigration judge. They were going to take his lawful permanent residence and deport him. He was applying for what's called 212C relief under the Immigration and Nationality Act. And when he went to immigration court, it was clear from the very beginning that the judge was fairly hostile to our client. He refused to allow the client to not accept responsibility for the crime. In fact, he pushed him and pushed us to make the client accept responsibility. He took over questioning on multiple occasions, which is permissible, but it was very aggressive questioning. He would cut us off. He would really just pounded on the client. I mean, he simply abandoned his role as a neutral adjudicator, in my opinion. The immigration judge would stop the tape recording during the hearing and have off-the-record conversations. Yes, immigration court still uses tape recordings, or at least some courts do. So we do FOIAs and we get recordings of proceedings and we get cassette tapes to listen to. During one of those times when the immigration judge stopped the tape, he literally said, "Counsel, you need to have a come to Jesus talk with your client so he admits that he committed this crime so he can accept responsibility and show some remorse." We filed a brief after the immigration judge filed a petition for review and then a brief after the immigration judge denied the 212C relief. Directly from immigration court, you go to the circuit court. So we were before the Ninth Circuit. It was a fantastic opportunity as a clinic student to write Ninth Circuit briefs and to actually argue a case in front of the Ninth Circuit. Almost all of our arguments were based on violations of due process. Off-the-record conversations, abandonment of the role of a neutral adjudicator, really just, again, pushing the client to admit something that he had maintained his innocence on throughout. When we got the government's initial response brief, the first argument that the government said is, there is no right to due process in immigration court, so therefore we win. And it just kind of astounded me that that was the government's first argument. Thank goodness that is not the law. Immigrants are entitled to due process in front of the immigration court. So we did win a remand before the Ninth Circuit, and eventually that client got 212C relief and is back in the community with his family. Next, I'm going to talk about those 5 different removals or deportations in which you don't actually get the right to see a judge. And the first one is what's called an administrative removal order. And an administrative removal order is begun by a low-level DHS officer, Department of Homeland Security. Usually it's going to be ICE, Immigration and Customs Enforcement, the police of immigration, or it's going to be potentially Customs and Border Protection, as the name implies, the folks protecting the borders. That low-level officer must make 2 determinations: that the immigrant is not a lawful permanent resident, and that the immigrant has been convicted of what's called an aggravated felony. The first determination, the immigrant's not a lawful permanent resident, it's not overly complicated, but it's also not a slam dunk determination. For example, our office has actually represented a U.S. citizen who was wrongfully deported from the United States. It does happen, mistakes are often made. The second determination, whether or not that person was convicted of an aggravated felony, is an extremely difficult determination to make. An aggravated felony is a term of art from the Immigration and Nationality Act. And because immigration law is all federal, and most of the convictions we are looking at are state convictions, we employ what's called the categorical approach. So you start with the federal definition of the crime or the generic definition that possibly comes from the Model Penal Code, and then you take the state elements of the crime and you compare the two. And if there is a direct overlap, meaning the same conduct is going to be punishable, the same elements apply under both the federal and the state definition, then that's categorically a match. That is an aggravated felony. You're done. If there is some overlap, but not exactly a direct match, then you move to what's called the modified categorical approach. And if the state statute punishes conduct that is broader than the federal statute, Then you look at the state elements and you determine if a jury must conclude specific elements for the conviction. And if the jury must conclude the specific elements for how the client committed the crime, then you can look at what's called the record of conviction. The record of conviction is a limited set of state court documents that include sometimes the charging document if incorporated in the judgment of conviction, a written plea agreement, and possibly the plea colloquy. And you use all of that to find out whether or not the conviction is an aggravated felony. Again, this determination, this person's life and liberty here in the United States is made by a low-level DHS officer who's not an attorney. Just to illustrate how complicated the aggravated felony analysis is, in the last 10 years, the U.S. Supreme Court has ruled 6 different times on whether or not a specific state conviction is indeed an aggravated felony. So it's not an easy determination to make, and immigration officials get it wrong all the time, and the results can be catastrophic. Once that low-level determination, or that low-level officer makes those 2 determinations, passes it on to another DHS officer, that DHS officer simply reviews it and signs off on it, and then it's served on the immigrant. That person has 10 days to challenge, and it's a very limited world of challenges that can be made, but 10 days to challenge that before the agency itself, and then potentially file a petition for review within 30 days of that determination being made. Again, that goes directly to the circuit courts. Oftentimes, immigrants are deported before their 30 days expire. Most of the folks in these circumstances are unrepresented, and there are also often language barriers. Many of the ICE agents speak some Spanish. They do the interpretation of these mostly documents that are in English for clients. We deal with mostly Spanish speakers. Other countries, I would assume or would hope that they get qualified interpreters, but again, some real significant problems. So some of the due process concerns that are involved in these types of administrative removal orders include, again, no right to an impartial adjudicator, no right to call witnesses, no right to appear and argue the case, and oftentimes, somebody is expeditiously removed before they even could file a petition for review with the circuit court. We had a client who the government chose to proceed in his case by issuing a notice to appear, placing him in removal proceedings. I went to court in front of the immigration judge, and we got a continuance at the first hearing. Before the second hearing, DHS, the Department of Homeland Security, filed a motion to terminate proceedings on the sole basis that now they wanted to issue an administrative removal order. I filed a strenuous objection. My client had invested time and money, working on a defense, going to court. Over my objection, the immigration judge terminated proceedings, and my client was administratively removed without a hearing before a judge. It's rough stuff. Next, I'd like to talk a little bit about expedited removal orders. So the statutory elements for an expedited removal order are that somebody is either found at a port of entry and they're inadmissible because of fraud or misrepresentation, or they're simply inadmissible because they don't have a valid visa to allow them in the country, or somebody is found anywhere in the United States and they can't prove that they've been physically present in the United States for the last 2 years. This process is also just initiated and terminated by a low-level Department of Homeland Security officer, and there's not even the need for a second officer to sign off on that determination. The regulations that talk about expedited removal orders do narrow the world of applicability. The regulations state that somebody must be found within 100 miles of the border, and they must be found within 14 days of entry. One of President Trump's executive orders indicates that the Department of Homeland Security will work to expand expedited removal to the fullest extent of the law available. Shortly after that executive order was signed by President Trump, the Department of Homeland Security Secretary Kelly issued a statement saying notice in the Federal Register will be forthcoming. Although we're not exactly sure what that means, advocates think that It will likely eliminate the 14 days within entry and the 100 miles of the border requirement. And what that means is that anybody found anywhere in the United States who can't prove that they've been here for 2 years or more is subject to being expeditedly removed. The way expedited removal occurs now, it's often the same arresting officer who does the paperwork. Again, those officers often act as the interpreter. There's no requirement for an impartial interpreter. Additional due process rights, you don't have the adjudicator. Happens quite often in one day, sometimes within a couple of hours. You have no right to call witnesses, no right to appear and argue. The government maintains that you have no right to appeal an expedited removal order. And even the Ninth Circuit has opined that in some circumstances there's simply no right to counsel. That's currently being litigated before the Ninth Circuit, and there's some great amici briefs that talk about issues with interpretation, one single agent being allowed to do this process within the matter of a couple hours. The third type of removal where you don't get to see a judge is what's called a stipulated removal order. And a stipulated removal order can be entered at the request of the quote-unquote alien. It's been my experience that immigrants are not requesting to sign their own deportation order. Many times it's presented as a bleak set of alternatives. You can fight your case, you're going to be detained, you're not going to win, you're going to go to some other state. For example, somebody who's detained in immigration custody in Idaho, there's no long-term detention facilities, so those folks are shipped off to Tacoma, Washington. So in that bleak set of alternatives, the other thing you could do is you could just sign this and we'll remove you tomorrow or the next day. And quite often with very little explanation of what they're signing, very little or no explanation of what rights or remedies or ways to fight their case they may have, the person signs their own removal order. The regulations do require that if the immigrant is unrepresented, it must go before an immigration judge, and that judge must determine that it's a knowing, voluntary, and intelligent waiver of rights. That sounds fantastic, except for nobody's in front of the judge. It's a paper review. And so the judge looking at that stipulated removal order just essentially rubber stamps it. I had a client who had been in the United States since 1986, had several U.S. citizen children. He signed his own stipulated removal order. The immigration judge affirmed it. Fortunately, they came to us. We presented arguments. He'd also been a victim of a severe beating that almost killed him, and he was eligible for a U visa, among other things. But we filed a motion to rescind that stipulated removal order on the sole basis that it was impossible for the immigration judge to determine it was a knowing, intelligent, and voluntary waiver, since he'd never seen my client and had no access to the conversations that occurred between my client and ICE. Fortunately, the stipulated removal order was rescinded. The client got a U visa and is now a lawful permanent resident here in the United States. Basically, a lot of the same due process concerns involved with stipulated removal orders that are involved with expedited and administrative removal orders. Another kind of removal order is what's known as an InAbsentia removal order. And an InAbsentia removal order simply means that the immigrant did not show up to court. In order to proceed with an InAbsentia removal order, all the government has to do is prove that address was sent by regular mail to the last known address of the client. We see numerous occasions in which there are problems with the address. We do FOIAs. We determine that no, it wasn't sent to the proper address. I had one client who lived in Nampa in sort of an apartment complex. There were 6 different units. They shared one mailbox. And 20 years ago, my client got an InAbsentia removal order because she didn't even know she was in removal proceedings, let alone get the hearing notice to actually go and attend court. So InAbsentia removal orders, again, are similarly problematic, a lack of notice, an opportunity to present a case, and the consequences can be devastating. The last kind of removal order in which somebody doesn't have a right to appear in front of an immigration judge is what's called reinstatement of removal. And essentially that allows the government to use any form of removal order, any of those that I've just talked about, or a judge-issued removal order and simply reinstate that order and deport the person again. And it does require that, so you've got the removal order and then that you unlawfully entered the United States thereafter. That reinstatement order is simply signed off on by 2 DHS officials, and reinstatement orders generally account for more removals, deportations from the United States than any other type of removal order. Once the reinstatement process has been begun, the immigrant has no right to the vast majority of forms of relief, again, and no right to see a judge. You can file a petition for review with the circuit court within 30 days after that reinstatement is signed. That petition for review doesn't qualify for an automatic stay, so your client could be deported in the interim, and you have a very limited manner of collaterally attacking the underlying removal order. Due process concerns, again, no interpreter, no impartial adjudicator, no right to a hearing. Oftentimes the client is completely unaware that they're being reinstated. Sometimes they don't even know about the initial removal order. I know I'm just about out of time. Lastly, but not least, is consular processing. Consular processing, and as an immigration attorney, is probably one of the scariest things that I have to do. So even somebody who's married to a U.S. citizen, you think you marry a U.S. citizen, that gives you something automatically? No, that gives your citizen spouse the right to file a petition on your behalf. You could still not gain status for a variety of reasons, but your only right to do the process for the green card here in the United States is derived from either a petition filed prior to April 30th of 2001 or entry with inspection. If you're not in those two categories, let's say you entered IWI, then to complete the process you have to depart the country and go before a consular officer. The thing that terrifies me about consular processing is what's called the doctrine of consular non-reviewability. It's derived from the plenary powers that Congress has regarding aliens, and essentially that says that determinations made by a consular officer are not subject to judicial review here in the United States. There was a Supreme Court case a few years ago called Kerry versus Dinn. It was a very fractured opinion. I believe Kennedy's concurrence, or at least the Ninth Circuit believes Kennedy's concurrence controls, and that simply requires that the consular officer have a facially legitimate and bona fide reason for denying the visa. We had a case recently that we took up to the Ninth Circuit. Client from Nampa left the country voluntarily to consular process. The consular officer determined he had, quote unquote, this is from the statute, reason to believe that the client wished to enter the United States to engage in illegal activity. Essentially, they thought he was a gang member, and that belief came from one single police report in which the client was arrested with 2 suspected gang members in the car. The client was actually driving without privileges. That was his only criminal record at all. The consular officer also made that reason to believe determination because our client had a tattoo that was the 2 mimes, the smiling happy mime and the crying mime, and apparently that is a gang tattoo, so don't get that tattoo. We challenged that at the Ninth Circuit, and the Ninth Circuit said, sorry, doctrine of consular non-reviewability. Your client is stuck in Mexico. He's not coming back to his U.S. citizen wife and kids. Have a nice day. Similarly, there's another ground of inadmissibility, very closely related to the reason to believe entering the United States for illegal purposes. That's reason to believe addict or alcoholic. I had a client who, again, voluntarily departed the United States. He had 2 U.S. citizen children. He went to his consular interview. The medical examiner doing his own interpretation. There was a miscommunication. My client admitted to smoking marijuana 1 time 8 years previously. Consular officer determined reason to believe addict or alcoholic. My client fortunately had done a drug test right before he left, but there's no recourse immediately. Our recourse was to reapply again 1 year later. So he spent that year in Mexico. We had him go do multiple drug tests throughout that period. After my client departed the United States, he learned his wife was pregnant with their 3rd child, so he didn't get to be here for the birth of his 3rd child. Fortunately, he successfully was able to re-enter the United States 15 months after he departed, and it was all because of a communication issue. So again, I love my job. Immigration law is fantastic. It's fascinating, but you don't have the same rights in immigration land that you might in the rest of the law. And Thank you, Cammie, for this opportunity to talk to everybody, and thank you, 4th District Law Committee, for putting on an event again this year. Thanks.
And we love having Chris here. He's been on the Law Day Committee for